briefing.
Afternoon, Tim Ford, staff with the Law and Justice Committee. And before you is the Law and Justice Striking Amendment to engross substitute House Bill 1169 relating to legal financial obligations. The crime victim penalty assessment is eliminated for juveniles in this bill. For an adult defendant convicted of an offense, the court must not impose the crime victim penalty if the court finds that the defendant is indigent at the time of the sentencing. And later, the court may waive the crime victim penalty imposed prior to the effective date of the act if the person does not have the ability to pay. Provisions indicating the crime victim penalty assessment may not be reduced, waived, or converted to community restitution hours are now removed from law. The DNA database fee is eliminated. Upon motion of the offender, the court must waive any DNA database fee imposed prior to the effective date of the act. Non-restitution legal financial obligations for juveniles are eliminated. No fine, administrative fee, cost, or surcharge may be imposed or collected by the court against any juvenile or juvenile's parents or guardian. The authority of the court to convert unpaid fines or monetary penalties to community restitution is removed. A judgment against the juvenile for any LFO other than restitution is not enforceable. The Superior Court clerk shall not accept payments. The courts are not required to refund or reimburse amounts previously paid towards LFOs or interest on LFOs. And the state shall pay any examination cost unless third-party insurance coverage is available related to treatment options to determine whether a juvenile is chemically dependent, substance abusing, or suffers from mental health issues.
Julie Murray, staff to the committee. You have in your electronic bill book a fiscal note for the engrossed substitute version of the bill. The fiscal impact of the bill relates to two items. The first is eliminating the local crime victims penalty assessment for juvenile and indigent adults. And then second is the elimination of the DNA database fee for all offenders. Under the bill, with the repeal of the DNA database fee, the DNA database account would now need to be funded with legislative appropriations. In addition, the bill changes the account and requires 20% of the funding to be distributed to agencies collecting samples and 80% of the funding to be used for the maintenance and operations of the DNA database. State Patrol's fiscal note notes it needs $1.2 million each biennium in order to backfill the loss of the DNA database fee and to provide funding to agencies collecting samples. The House Chair budget fully funds request at $2.4 million over the 4-year outlook. In addition, State Patrol requested 1 FTE to administer the account and to distribute the funding to counties at an estimated cost of $246,000 each biennium, and the House Chair budget fully funds this request for $480,000 over the 4-year outlook. The bill also creates the State Crime Victims and Witness Assistance Account in the State Treasury. This is a replacement to provide funding for victims with the elimination of the local crime victim penalty assessment. The account shall consist of funds appropriated by the legislature, and pursuant to appropriation each quarter, the state treasurer must distribute monies deposited into the account to counties based on the county's distribution factor under RCW 8214-310. That statute is the county's criminal justice account distribution factor, and that is based on population, crime rate, and cases filed in Superior Court. Counties may expend these monies under this section only for crime victim and witness programs in counties. The House Chair budget provides $8.2 million general fund state each biennium into the new account for $16.4 million over the 4-year outlook. I've not had an opportunity to discuss with my House counterpart the calculation of this amount, but if you factor that into the fiscal note, the 4-year outlook cost of the bill in the House Chair budget is $18.8 million. I do want to note that the fiscal note shows a revenue loss of $520,000 each biennium general fund state that I believe is an error, and I'm in conversations with the Office of Administrative Courts to correct this. And with that, I conclude my remarks and am available for questions.
I don't see any questions. Thank you both for your briefing. We have 5 people signed in to testify on this bill. Alex Herr, Evan, we'll go to Evan Walker remotely, Vicki Christopherson, and Hannah Warner, if you could please come forward. And Evan, if you are ready, you could go ahead.
Hi, sorry. Good afternoon, Vice Chair Robinson and members of the committee. For the record, my name is Evan Walker, and I'm a senior policy analyst at the Washington State Budget and Policy Center, testifying in strong support of engrossed substitute House Bill 1169. House Bill 1169 advances economic and legal justice in Washington by granting relief to adults and youth from mandatory LFOs and funding court services from more reliable sources that include state appropriations. Research shows that Washington spends 3 times as much on collecting non-restitution fines and fees from youth than it receives. Further, collections from juvenile fines and fees are low, bringing in little revenue at high cost to youth and their families. House Bill 1169 rightly eliminates the mandatory victim penalty assessment and DNA collection fee and the rest of discretionary LFOs for youth. This bill also eliminates the VPA for adults who do not have the ability to pay, reducing the funding backfill for the Crime Victim and Witness Fund, and freeing up state time and resources from collecting people who can't pay. I urge your support in passing this bill. Thank you.
Thank you. Alex.
Good afternoon, Chair Rolfes, Vice Chair Robinson, and Ranking Member Wilson, and members of the committee. For the record, my name is Alex Herr, testifying on behalf of the Statewide Poverty Action Network in support of House Bill 1169. The problem that we're trying to address with 1169 is to ensure that the judicial system operates both fairly and equitably. 1169 frees up our county clerks from having to spend dollars to collect dimes, as recent research shows that they spend about $3 to collect the $1 in fines and fees. We would ensure that the Crime Victims Compensation Fund are adequately funded and gives low-income formerly incarcerated people a chance to rebuild their lives. 1169 would end the cycle of hopelessness for a person who's trying to rejoin our community after serving their sentence but cannot find adequate work, adequate shelter, and cannot pay off their LFOs, but also can't vacate their sentences because they can't pay off their LFOs. It's a vicious cycle, and we hope that 1169 is passed this year to end it. Thank you so much.
Thank you. Vicki.
Yeah, thank you, Madam Chair, members of the committee. For the record, I'm Vicki Christopherson, here today on behalf of the Justice Action Network, testifying in support of this legislation. Not to repeat what others have said, what I'll add here is that this is part of a conversation that's really going on nationwide. States are recognizing not only are these fines and fees not collectible, as mentioned by Alex and others, but also that they have no direct correlation on whether somebody will reoffend. So states like Louisiana, Michigan, Texas, and Oklahoma, we're following in the footsteps of those as we try to right-size our criminal justice system, make it fairer, more efficient, and more tied to actually reducing crime. Thank you.
Thank you. Hannah.
Good afternoon, Chair Rolfes and members of the committee. I'm Hannah Warner, testifying on behalf of Columbia Legal Services in strong support of engrossed substitute House Bill 1169. Our court should not be funded through fees levied on the poorest members of our community. The bill before you today has a significantly lower fiscal impact than a previous bill that this committee considered. That earlier version totally eliminated the victim penalty assessment, or VPA, for adults, but after extensive engagement with stakeholders, we reached a compromise to only waive the VPA for individuals who are indigent. With this bill, we can still collect VPA revenue from people who can afford to pay, and those funds will continue to come in as revenue for crime victim services programs. We urge this committee to consider any additional funding needs for programs funded through the VPA through the budget, keeping in mind the strong equities in favor of eliminating mandatory fines and fees for people living in poverty. Thank you.
Thank you. Russell Brown. Keeping you busy this afternoon.
Thank you. Again, Russell Brown, Executive Director for the Washington Association of Prosecuting Attorneys, here testifying other on House Bill 1169. I want to be clear that we are not opposed to the policy. Our opposition or our concern here is really tied to the fact that victim penalty assessment is 100% sent to prosecutor's office to fund a victim witness program. The removal of, or to make it a discretionary LFO, will decimate those programs. And so we're asking that if if those policy decisions are made, and again, we have no opposition to that policy. We just want to make sure that the funding is there to backfill that. We appreciate that the House did include that in their budget. There's about $4.2 million per year. If there's some way to make that more efficient or effective, that's fine. We just don't want to lose the current good staff that we use right now to help victims and witnesses of those cases. Thank you very much.
Thank you. That concludes the public hearing on engrossed substitute House Bill 1169, and we'll move on to substitute